tonight, joining us to break this case down, we have trial attorney and federal litigator Alexis Rosenberg and trial attorney Tray Gober. Yeah, and let's talk about those inconsistencies, Tray. It does seem to me as though when a defendant has different stories, that shows consciousness of guilt. How is the jury going to react to the fact that he said different things? First, there was just the shooting. Then he said there was a gun that was being shot at him. And, I think that's going to make a difference, right?
Exactly. This is why criminal defense attorneys advise clients all the time, don't talk to the police, because there's going to be these inconsistencies. Certainly the defense is going to have explanations for these inconsistencies. They're going to talk about it's a nervous interaction with police. They're going to talk about the defendant's age to try to explain why there are these inconsistencies. But what'll ultimately be really bad for the defense to try to overcome is the inconsistencies are always in favor of the defendant's position. And that is, as you said, shows the sense of guilt on his part.
Tray, what do you think here? I mean, she could have said nothing with an opening. She could have actually just passed on doing an opening statement at all.
There was a lot of argument in the opening. There wasn't a lot of what the evidence will show. It was a lot of what the evidence won't show in her opening statement. But I'll say the thing that I think the defense attorney did that is really dangerous is she made a commitment to the jury that the evidence is going to show that somebody else perpetrated this murder. And that's too big of a bite. She doesn't need to take on that burden. All she needs to say is there's going to be reasonable doubt at the end of the day as to whether my client is the one that shot that bullet. But to say that somebody else did it without any evidence to support that, the jury's going to hold her accountable for those promises and those commitments, and there's not going to be that evidence.
All right, I have with me Alexis Rosenberg and also Tray Gober. Tray, this is for you. Do you think the judge made the right decision there? I was going to guess that, yes, it's going to be let in. It's not, prejudicial, or if it is, it's more probative. What are your thoughts on that?
Yeah, it's a tough one. This one is, basically a discovery violation allegation under Georgia law. The state cites the exception if it's a purely oral statement. The law, is set up so that there's at least 10 days before trial notice. And what's not typical is that we have a trial go for so long. And so I think that's what the judge is saying here is, look, I'm not sure this had to be produced at all, but even if it did, you've got more than 10 days before this witness takes the stand to have prepared adequately in response to these alleged statements.
That's exactly right. Yeah, I agree with you 100%. All right, I still have with me Alexis Rosenberg and Tray Gober. Tray, this goes to you. This prosecution's opening, I think, was fairly straightforward. I think it was succinct. And I think he's laying out his case for first-degree murder. Do you agree?
Absolutely. He's hitting all the targets. He pointed out that the defendant waited until they were alone. If somebody's acting just out of passion, which might be one of the defenses that the defense could raise, you're basically temporarily insane, out of your mind. It's not cool, calm, calculated to wait for everybody to leave. The self-inflicted defensive wounds, you can see the defendant, was planning maybe a defense there or just trying to take his own life. And so it's very matter of the fact, but it also is hitting some of those elements like no blood left in the heart. That's something that's going to stick with the jury. It's very visual for the jury. So he's got them hooked at that point that this is a very bad thing that's happened, and the defendant needs to be held accountable.
I'm going to start with you, Tray. I also have Alexis here with me. One of the questions I think the viewers might have is, look, the charge here is first-degree murder. It's premeditated. She's already admitted that there was a killing by her client, but there is no charge in the indictment for second degree or any other lesser included. How will the defense actually get that into the case if, in fact, they're not presenting any evidence? How could they, give the judge the opportunity to put this lesser included into the charges if, in fact, it comes down to that?
So before the charge, the instructions of the court go to the jury as to what the potential charges are, the defense is going to have an opportunity to ask the judge to include lesser included offenses. It certainly will involve the death of Alexis, but missing some elements, for example, the premeditation element. And so the defense will seek out to have included in part of the charge, the instruction from the court, some of these lesser included offenses. The jury won't know the ultimate effect, punishment, how severe one charge is versus another charge. And the defense will make the argument that some of these lesser included charges are going to be more appropriate. And you heard that from the defense, that the defendant is not guilty of at least some of the things charged with. They're anticipating there's going to be lesser included charges.
Exactly. Tray, why do you think she actually stepped down? Do you think that she's thinking she's going to be, found somehow responsible or culpable, and she's just trying to head off the path?
It's possible. She had the upcoming deadline of April 1 to announce whether she was going to run again for clerk, run for the office. So she basically had a very short timeline to make a decision anyway. Part of this might just be saving face for her career. She knows a lot of people there in the county, and she wants to make a statement as to why she's not running again and kind of put a little spin on it in her favor. But certainly it probably has a lot to do with publicity for the book.
Tray, one of the things I was thinking of, there was so much evidence in this case. The fact that if she in fact did say these things to the jury, that she basically sort of goaded them and pushed them in the direction of a guilty verdict. If all of those things are true, it's a shame, because there wouldn't be this problem if she just hadn't said anything.
Exactly. And the judge ultimately said what she did, while inappropriate, didn't make a difference at the end of the day. We'll see what the appeals courts do with it. Certainly this defendant is well-heeled and going to be capable to pursue this defense and his appeals to the nth degree. But maybe the irony of all of it is, if all of this was to sell a book, the book would have sold a lot more had Mr. Murdaugh been found not guilty. For example, look at the O.J. Simpson case. We're still talking about it because of the not guilty verdict. And so for her to put her thumb on the scale for purposes of selling the book is counterintuitive, but it just shows that she really wanted more of a role in this trial than she really should have had.